Let's see, ladies and gentlemen, it's time to call the first bill. Want to let you know before we do that, today will be hearing only, but these bills will be back on the calendar for next week, and we'll take a vote at that time. So we're going to reverse the order that they're listed on the agenda. I understand that House Bill 960 is the shorter of the two, so let's go ahead and take care of that. And Representative Leverett, then what number are you over there? Yeah, that helps. Thank you.
Thank you, Mr. Chairman. I appreciate that, members of the committee, and appreciate the subcommittee's consideration of these two bills of mine today. The first one is House Bill 960. The LC number is LC 44-1859. And this bill would provide a statutory framework or foundation for the Office of Inspector General. Now, if that sounds familiar, it's because this subcommittee, I believe, actually considered a similar bill that was filed by Representative Barr last year that got assigned to Government Affairs and then came to this committee as a committee sub at one point. And I appreciate Representative Barr. Obviously he's got some other things going on this year in his life, so he had allowed to ask me to carry the bill. It's, I think, a very important bill because it would provide that statutory framework to an entity that currently exists only by executive order since, I believe, 2009. Scott McAfee, the current Inspector General, is here to testify in support of the bill, and he can talk more about what his office does and why they need this bill, and can answer questions about it, as can I, Mr. Chairman, if anybody wants questions about the details of the bill. But I also want to thank my co-sponsors, Chairman Oliver and Representative Wilson, as well as Representative Barr, who all co-signed onto this. And I think Scott can go into this in greater detail, but having a statutory framework will make the Office of Inspector General a more efficient and effective investigatory tool to root out corruption, abuse, and fraud within the executive branch. And I think that's their reason for existing, and that's their purpose. And so this would be very, I think, beneficial to them. And so that's sort of the bill in a nutshell. And I don't want to take any further time away from the Inspector General.
All right. If I get the Inspector General and whoever else to come up here, please. I think we have the mic to your left set up.
This is the live one.
Yeah.
Thank you, Representative Leverett and Mr. Chairman and honorable representatives. And thank you for allowing me the opportunity to speak for a few moments in favor of House Bill 960. This is the bill that would finally codify and grant law enforcement authority to the Georgia Office of the Inspector General. This bill is about transparency and accountability. At its simplest, the Inspector General exists so that the public can trust and have confidence in our government. We are an independent and objective watchdog agency that's tasked with policing fraud, waste, corruption, administrative violations, ethical lapses, and sexual harassment throughout the entire executive branch. And just a bit of background, the concept of a civilian IG in the United States dates back over 40 years. Since the passage by Congress of the Inspector General Act of 1978, there are now over 75 different inspector generals at the federal level, and those compose over 13,000 federal employees and $2 billion in the agency budget every year. At the state level, however, Georgia's IG office was created by executive order from Governor Sonny Perdue, in 2003. And 10 other states now have statewide offices, and all of those 10 states have some kind of statutory authority or subpoena and law enforcement power. And after 18 years, it's time for Georgia to join those states and make Georgia's OIG a truly effective crime fighting and fraud preventing organization. Because despite our limited authority, Georgia's OIG has historically delivered remarkable returns for this state, saving millions in taxpayer dollars and completing dozens of successful prosecutions at the state and federal level. And just to highlight some of our work over the past year, in which we have pointed out in the annual report that we posted online and shared with each of y'all today, a recent administrative case that we closed in September focused on the Special Investigations Division at the Department of Revenue. In that case, we made the administrative finding that there had been over $5 million in civil forfeiture funds that had been unlawfully retained, and $3 million of that spent by the agency. But because we were able to focus on that and make those findings, our recommendation that $2 million be returned to the state treasury was accepted, and we moved forward with the other administrative findings in the case. Another example, there was one of our cases that we are still ongoing in a criminal investigation involved a business email compromise scheme. It's a very common fact pattern that we come across now, but it's one of our major agencies here in Georgia was hit and a $1.3 million payment was diverted to an unlawful account. OIG was able to swiftly intervene and was able to reverse payment of $450,000 of that payment. And we proceeded with the investigation on the remaining funds, and we hope to present that to a grand jury very soon. But we think we can do much more, and this bill will allow us to do that. And so what exactly is in this bill? It's based on model language compiled by the Association of Inspectors General. That is a national organization. It's based on our current executive order and on legislation passed by other states. As I've mentioned, most importantly, this bill grants our office law enforcement authority and allows us to seek subpoenas and search warrants, because our lack of designation as a law enforcement agency has impeded our criminal investigations and effectiveness in a number of ways. First, if we had law enforcement authority, we could assure and promote the safety of our investigators. There are a number of instances in our cases where it limits our ability to do what we need to do to complete an investigation because we don't have that authority. So for example, in a recent case that we're investigating where a state employee misused a P card to the tune of over $30,000, we need to conduct an interview of the employee. She's since been fired from state employment. But we know that the person she lives with is a convicted felon with a violent past. I can't ask my investigators to go knock on her door and get that interview in good conscience because they are not able to have that badge and to carry that gun. But we know that getting that suspect interview can be one of the most crucial and important parts of any criminal investigation. Another example, there was an occasion where investigators were on active surveillance of a suspect and they knew he had an active warrant. They located him, but they couldn't arrest him because they didn't have law enforcement authority. So he was able to evade and wasn't actually apprehended until sometime later. But second, and most noticeable on a day-to-day basis, the lack of this authority slows us down. White-collar fraud cases are notoriously time-intensive and slow, and speed is important. When cases aren't brought to justice quickly, criminal suspects can get rehired. They can reoffend. We see that they get laid off at the state level, and while we're conducting our criminal investigation, they get rehired elsewhere. We know that the longer a case drags on, the possibility of us recouping any money through civil forfeiture lessens over time as well, because that money is spent, it's laundered through other accounts, and it disappears. Our lack of authority slows us down by inhibiting our ability to obtain evidence. Very often we ask and we request evidence, and people say, we would give that to you, but you're not a law enforcement agency. And so we have to seek other means. And it diminishes our deterrent effect. A case that is indicted 4 years after the act is going to have much less of a message sent to potential future perpetrators than one that's brought swiftly. And we know that the opportunity to commit fraud becomes more acceptable when fraudsters believe it's going to go undetected and unpunished. The third reason that this law enforcement agency is important is because it's going to open the door to us obtaining federal resources. We have been offered, there's a seat at a desk promised to us in the past by the FBI task force here in Atlanta for a task force officer position that they would fully fund. But we can't accept their offer because we don't have that authority. It would also open doors to grant money and other applications that we could find in that realm. And finally, it also just promotes investigative overlap and draining other agency resources. Every subpoena we seek, every search warrant we want, we have to go to the Attorney General's office or the GBI, and that slows them down and impedes their other investigations that they're having to work on at the same time. So ultimately, in addition to the law enforcement authority, I would also mention that the bill codifies our focus on being proactive through the authorization of audits and evaluations, because it's always much more cost effective to catch fraud before it ever occurs. And our goal will be to find those vulnerabilities, to constantly reevaluate our state agencies' preventive and detective controls, and to make recommendations to improve them in the future. The remaining provisions of this bill have that goal in sight. They're designed with a focus on the independence of the office, an office that is supposed to be apolitical, and its effective oversight of our agencies. So in closing, I would urge each of you to vote in favor of this bill because Georgians deserve a government free from fraud and sexual harassment. And a strong IG's office can determine the character and conscience of the executive branch and simply make our government work better. So with that, I thank you for your time.
All right. Does anyone have any questions for the author or Inspector General McAfee? Start over here. Who's got number 5? Okay. It looks like. I guess you say.
Thank you, Mr. Chairman. Thank you for presenting the bill. Thank you, Representative Leverett. I have 2 questions, if it's okay, Mr. Chairman. First, is there anything in the proposed bill or anything in the Inspector General's authority as exists currently under executive order that couldn't be done by the Attorney General's office currently?
Representative Evans, thank you for the question. Currently, as it relates to the executive order, they've carved out this space for us to be an independent oversight agency of the Attorney General's office. So I think the bigger picture would be, is the Attorney General's office tasked with overseeing itself? And the answer is, of course they do, but that there always be that also that independent oversight. So the executive order does grant us the ability to interview any other state employees in the executive branch, to obtain documents from other agencies. But those are powers that are also contained by the Attorney General's office, and that is why they are our go-to agency when we need to obtain those. But the IG's office finds a niche in focusing on an aspect of government the AG's office does not, which is, again, the ethical lapses that may not always be criminal, the administrative violations which the AG's office does not look into, and again, more recently, the sexual harassment cases.
Understood that they don't, and that we appreciate that they keep a lookout most intently for criminal issues, but could they? Is there anything that prevents the Attorney General's office from, for example, creating an Inspector General within its office to do exactly what we're proposing with this legislation?
I suppose that is a possibility. That is not one that we've explored or I've heard of any interest on their end of doing. And I would stress the importance of having that independence between agencies and oversight.
Thank you. And my second question relates to lines 40 and 41, where we talk about the governor shall appoint an Inspector General who shall not be removed from office except for good cause. I understand why you would want that language there not to be removed from office for good cause, because you don't want the governor getting mad perhaps that the Inspector General is doing an investigation that he or she doesn't want to be done and removed for no cause. But I do have concern that we create a position of that one person has in perpetuity, that there's no term limit, there's no natural place to get off, there's no evaluation, this person could just sit there as a czar who has tremendous authority. And so I was wondering how that language was arrived at, and also for the other states that have similar offices, how does this compare to how they select the Inspector General and how they deal with what looks like a perpetual position? Certainly.
It is not a new concept. This is something that is found in, I know offhand is found in, I believe, New York's Inspector General statute, and it's one that's found at the federal level. So the Inspector General Act of 1978, when it was set up, there are no term limits for federal Inspector Generals. They serve at the pleasure of the president or of the agency head. And what we actually see historically is that Inspector Generals do not change over in administration. They continue indefinitely from one to the next. And I think that, again, goes to the ethics or the character of them being an apolitical organization. And so from administration to administration, you will see IGs continue. Some have been there for a short period of time, 2 to 3 years. Others have been there much, much longer. And so this emulates the federal model of there not being a term. The good cause provision comes from the model language by the National Association of Inspector Generals. And it's exactly what you pointed on, is that there should be some level of independence. And that if a case does come up involving the governor's office, that investigation cannot be immediately shut down just through a firing.
One follow-up, I don't want to beat a dead horse here, but if the federal rule, the federal model, you said the Inspector General serves at the pleasure of the president, just because the president hasn't always exercised pleasure, a new president hasn't exercised his pleasure to change, he could, or she could theoretically one day. Here we don't have that. This person is in. Whoever the governor is, when we pass this, appoints the Inspector General. And unless that person does something that would qualify for removal for good cause. That's it. Forever and ever. Amen.
Essentially, that is the good cause effect is that's the balance you have. Is are we going to, it's a step towards independence versus a political transition. And that's the balance that must be struck whenever we're talking about the oversight concept. So I think that it's a fair point, and it's one that one of the factors you have to weigh when crafting how we're going to form an Inspector General's office.
Thank you.
Representative Kelly.
Thank you, Mr. Chairman. Mr. Inspector General, thank you for being here with us. I guess my question is, do you anticipate having to hire any additional investigators because of having these new powers? And if so, have we already built those into the budget cycle?
Our goal with this bill is just simply to get this law enforcement authority. That is our primary goal. We are not coming here asking for more money, asking for a major expansion. Down the road, if we can show you what we've done and that we deserve it, sure. But right now, we see this bill as essentially negligible when it comes to revenue. Our projections are that to get the post-certified training, the badges and guns and bulletproof vests and other things like that, that the impact is going to be anywhere between $200,000 to $250,000. We've also anticipated adding maybe in a criminal analyst position, but other than that one single additional position, we are not asking for an expansion of the office.
Okay, thank you.
All right, and Representative Oliver, I think, on 17.
Thank you, sir. I'm a co-sponsor. I support it. I'm going to vote. My questions are similar. Representative Evans, the GBI, the Ethics Commission, and the Health Special Unit of the Attorney General all have investigative law enforcement entities. Tell me how you coordinate with them. Some of your cases would be big enough. Do you automatically call in the GBI sometimes? How does that really work?
There have been occasions in the past, certainly, where we have coordinated with the GBI. I can think of one, in fact, where we had an investigation involving a GBI agent, and that's where they asked us to step in kind of as a conflict agency. Obviously, we work hand in hand with the AG's office on just about every case we have, because they're the ones we're hoping to refer our indictments to. They're the ones we're going through and working at the cases with the attorneys in their office. The Ethics Commission, I believe, since their jurisdiction is solely related to more of our elected officials in the legislative branch, the executive branch, we don't really have much interaction with them because we're focused more on state employees.
Where do all the sexual harassment complaints go? In a variety of different places, I think. Can you talk to me about that?
Absolutely. I mean, that is one of our core missions at this point, ever since Governor Kemp's executive order in 2019. And the framework that we have set up is that every single sexual harassment complaint in our executive branch, they're supposed to at least, they're supposed to provide notice to our office. We have an online portal where they enter in the details. And then if there is a conflict of some kind, say HR asks us to step in, or maybe the target is someone who's at a high managerial level, we will step in and actually conduct that investigation. But on the whole of, as I recall, in fiscal year 2019, when we did the sexual harassment audit, and there were about 180 sexual harassment complaints filed, we stepped in and did anywhere between, I think, 5 and 8 independent evaluations where we needed to ensure that there was independent oversight where there was a conflict. But we are the clearinghouse for those. And then we will write the report, we will gather the facts, we'll deliver that report to the agency leadership, and then they are left to make the decision on what to do.
So you really have some significant coordination management decisions to make on a number of different levels with.
We rely entirely on our relationships with the agencies. We don't see ourselves as a hammer in search of nails. If we don't have those partnerships, we can't do our job.
And just finally, Mr. Chair, I'm thinking and being persuaded a little bit, and we'll discuss it further. I know that there has to be some definition of ending Inspector General service by somebody at some point other than good cause. I think that's a valid point. So talk further about that.
All right. Okay. And Representative Holcomb.
Thank you, Mr. Chairman. I have a few questions. I get the concept. I've conducted internal investigations. I've defended people in internal investigations. I'm a former Army officer. They have a pretty good IG system throughout the force. So I get the concept. I have a couple of just specific questions with that in mind. On lines 66 and 67, it says prepare and release written reports to the public as deemed appropriate by the Inspector General and to the extent permitted by law. I think I understand why it's discretionary, so you don't have to write reports nonstop. But at the same token, one of the main drivers of this is to instill public confidence in the government. And so can't you give me some, or give the committee rather, some guidance in terms of what factors would be considered in determining whether or not a report is appropriate and would be shared with the public?
Absolutely. And I think that is absolutely an important consideration. I know that, again, the goal being is transparency, and we want to show the work that we've done. And federally, you can go on every single OIG website and see dozens and dozens, if not hundreds of reports for every little thing that they've looked into. I think that the consideration here, whether to release a report is going to come down to if there is certain sensitive information in terms of perhaps a whistleblower's identity, if there's something that we think might impede a criminal prosecution that's currently ongoing because of the report of information that might be in the report that came out initially. So, that obviously would be something that we would have, the principle being is a presumption in favor of release. But there is a clause in there that allows, and that the nature of a case-by-case basis sometimes need to be made, that certain aspects of it either need to be redacted, or if some maybe report's been finished, but because it has ties to another ongoing investigation, that it's not appropriate to release at that time. So it just allows some flexibility in that transparency.
Okay, that makes sense. And there are some agencies too that just because of size, it wouldn't be too difficult to figure out who was likely making the report as well, I would suspect.
Right, and that is a reality, especially when we start getting into the position of a complainant or background information of how long they've been in an agency, and that's something we have to try and balance and deal with.
Okay, and then a follow-up question, if I may, and I don't know the answer to this, is just below that, it talks about audits of relevant agency policies and procedures, all of which makes sense from a compliance standpoint. Are all of our agencies required to have written policies and procedures, and do they?
I can't speak definitively as to all 80 of our agencies, Representative Holcomb. I know that the ones that we've investigated, we've been consulting their policies. So one doesn't come to mind that doesn't have one. And I don't think this bill sets a requirement for them to have one. So if there are some, and we're talking about the policies of, I think the focus here would be if there's a certain program, for example, with a federal grant that's giving out money, and we find fraud, we step in and we see that there was a control missing, for example. We're going to try and make a recommendation to those policies of perhaps we should verify this before getting out that money. And that's what we're looking at in that clause.
Okay, and then just a couple more questions, if I may. With this, you'll have the ability to take depositions and sworn testimony, correct?
That's right.
Okay, and is there any right of counsel provision or requirement, since you'll have criminal jurisdiction?
Well, there's certainly going to be, what we do now is what we will continue to do, is give every state employee guarantee rights. They're not going to be in custody. So Miranda wouldn't play in, but if for some reason it does, we're going to advise them of that. And it's already our practice is to record any interviews with the target suspect, and to have them, if it's a video interview, acknowledge guarantee rights. We'll show them on the screen that they can read them. And we've had plenty of interviews that if they ask about an attorney, we end it. So I think that the concerns about representation would be addressed as long as we continue that practice. And there's a penalty if we don't.
Right.
Obviously, the case goes away.
Right. Okay. Thank you.
All right. Representative Kelly. All right. I don't see anybody else, nobody online asking a question. Still, all right. All right. Thank y'all. Appreciate it.
Thank you for your time.
All right. Now we'll move on to House Bill 916. And Representative Leverett, I'll start out with you.
Thank you for your consideration of what I would call some light reading. House Bill 916, which is the Georgia Superior and State Court Appellate Practice Act, which is LC 490656. We're going to have the benefit of a number of distinguished witnesses today, so I'll try to be brief and just give a very quick overview of this bill and its history. As a general overview, the bill would establish a single unified procedure for appealing from a lower adjudicatory, and I hope I'm pronouncing that term correctly, to a state or superior court. So although we use the word appellate, and rightfully so, we're talking about appeals to state and superior courts, not from them to what we traditionally refer to as our appellate courts. House Bill 916 is the culmination of years of work that began in July of 2016 when the Certiorari Review Subcommittee of the Judicial Council and the Standing Committee on Legislation Subcommittee were created for the purpose of reviewing the current certiorari review procedure. And again, we're talking about certiorari from a lower body to a superior court, not the one that involves the Georgia Supreme Court. The goal of the subcommittee was to simplify, improve, and modernize the process of appealing from municipal, magistrate, and non-Article 6 probate courts to state and superior courts. And after a lot of work, which I can claim no credit for, I believe House Bill 916 accomplishes that goal. So admittedly, the bill is lengthy. You know, Mr. Chairman, that's sort of becoming my wheelhouse. But I would point out that it would actually reduce the number of code sections governing appeals to superior and state court from 39 to 21. And I would also say, to aid in your review of the bill, the first, I think, 22 pages of the bill, just those first 22 pages, encompass the primary substantive provisions. That's where we set forth the new procedure. And then the remaining pages are just conforming, clarifying, and technical amendments. And for the most part, they're correcting cross-references in the code to a current procedure to update them to the new procedure, which this bill would adopt. So we've got the pleasure of a number of witnesses in person and on Zoom, judges and practitioners who can give background on the process, their perspectives on the current procedure, which we're changing, and explain why the legislation is so badly needed. To provide a short history of the project and policy improvements to the bill officers, we have Court of Appeals presiding Judge Christopher McFadden here to provide the section by section technical review for which this committee has passed into the realm of legend. Darren Enns is here to provide that, Assistant General Counsel of the Judicial Council and Administrative Office of the Courts. We also have to describe the project context and state the policy goals are Judge Gary Jackson with Fulton County Municipal Court, who's here in person, and Judge Michael Barker with Chatham County Magistrate Court, who I believe is here via Zoom. And to further talk about the current appeals process and problems with that process from a judicial perspective, we have Judge Margaret Washburn with the Sugar Hill Municipal Court, who is here by Zoom. And then to give the perspective from a practitioner's point of view, we have attorneys David Metzger and Brandon Bullard, who I believe are both here by Zoom. So I want to thank you again, Mr. Chairman, and the members of the committee for your consideration of this much needed bill. I've got to appear before Chairman Carson in a few minutes, and so I might need to step out before the testimony is completed. But I would ask that you favorably consider this bill. I know we're taking, I think, additional hearing next week, and so we won't have any action today, but would ask that you please keep that in mind. And finally, I want to thank my dear friend, Representative Walensky, who's been sort of a role model to me. Thank goodness he has pity on Republicans and other lower class people like me, and he agreed to co-sponsor this bill. So I greatly appreciate that.
All right. We better do both. Okay, we've got, let's see, Darren Enns.
Yes, sir.
Assistant General Counsel to the Judicial Council, AOC.
That's right.
And Judge McFadden, presiding Judge McFadden, thank you for being here. And I don't know who wants to go first, but let y'all go.
Thank you, Mr. Chairman, members of the committee. Thank you, Representative Leverett. The basic purpose of this bill is to bring the procedure for superior courts exercising their appellate jurisdiction into the mid-20th century. In the 1960s, the Appellate Practice Act and the Civil Practice Act were adopted in this state, and they replaced a confusing maze of writs with one civil action, one notice of appeal. That confusing maze of writs exists now with respect to invoking the appellate jurisdiction of our superior courts. You have to pick at your peril between a writ of mandamus, a writ of certiorari, or the statutory appeal procedure, and as well as potentially other equitable writs. I've actually been involved in this issue for some 20 years. I took a run at it that long ago through the state bar, and around that time, when the state bar was building its parking deck, they had an issue about some trees that were in the way, and they and their counsels, the Sutherland firm, were unable to figure out exactly how it is that they appeal decision of the Atlanta City Tree Commission. The idea is a single procedure, a petition for review, filed with the clerk of the Superior Court, which is exercising appellate jurisdiction. The idea being that some of these judicatories, particularly those that are not courts, don't have a proper clerk or clerk analog available in the way that you would expect a clerk of court to be available for the filing of a notice of appeal. And the idea then is that the Superior Court would exercise its legal judgment and make a determination of what standard review applies and what remedies are appropriate, rather than requiring that decision to be made at the selection of a writ. Otherwise, the lengthy bill just borrows as appropriate from the Civil Practice Act and the Appellate Practice Act, undertakes not to fix things that aren't broke, particularly although it brings in the state court's appellate jurisdiction over small claims decisions in magistrate court. It leaves it alone. Likewise, it leaves alone the Administrative Procedure Act, and otherwise reaches out to conform the various portions of the code that reference these procedures, and therein comes much of the length. So that is overall what this complicated bill does. And Mr. Enns and I have been working hard on this for a number of years, along with the rest of Judge Jackson, the rest of our committee, but he's been working harder. And I will rely on his expertise for most of the very close questions you may have. Thank you, Mr. Chairman.
All right, good afternoon, everyone. I'm Darren Ince, Assistant General Counsel at the Judicial Council Administrative Office of the Courts. And as presiding Judge McFadden suggested, I've been working with him very closely on this bill for over 3 years now. And it predates me at the AOC working on it as well. So we're very grateful at the opportunity for the General Assembly to consider it, as it's been quite a journey to get to this point. As Judge McFadden has suggested, this is a complicated issue as it currently stands, and we intend to simplify it by creating a unified appellate system from your lower courts and your local boards exercising quasi-judicial jurisdiction up to the superior and state courts for their review. And so in doing so, we attempt to pull in as many of those decisions as we can without upsetting much of what's already in the code. We've left everything alone that we could, while consolidating two separate systems into one. And the committee has been provided with an executive summary of the bill for your reference. And I think it serves as an excellent structure for us to kind of go through the bill together. And I'll make it as high level as possible so that we have time for any questions that the committee may have. So at the outset, we can start from the beginning, starting at online 30, we're retitling Chapter 3 of Title 5, Superior and State Court Appellate Practice Act. And that's pretty self-explanatory there. We're down the line in the legislation, you'll see that it repeals Chapter 3 of Title 5. Now, these two chapters are what provide for the notice of appeal procedure and the writ of certiorari procedure. So we're repealing those two existing chapters and replacing it with a new chapter that, as Representative Leverett suggested, would bring our total number of code sections from 39 to 21. So we're basically cutting that about in half and consolidating the process. Now, really, when it comes down to it, this entire bill is really, the theme of it is access to justice. And the reason for that is that even for our very learned practitioners, a couple of which we have on Zoom available to discuss the current process and the problems with it, it's complicated for most lawyers to navigate. And it's impossible for self-representative litigants to navigate. And as a result, the majority of these cases are going to be dismissed on procedural grounds, and you're not going to get to a decision on the merits. So our system, the hope of our system is that it will get more cases to a decision on the merits so that there's more justice and less procedural dismissals. And that's really the theme in our proposed code section 532, starting on line 33, and basically putting into the General Assembly findings something that our subcommittee of judges have observed across the state, and that the current system just isn't working and that it needs to be modernized. So that's basically the findings there. And one thing that's important that Judge McFadden pointed out is that we're not going to change the appellate jurisdiction of the superior or state courts. We want to leave those the same. We're just changing the procedure by which that appellate jurisdiction is invoked. So that said, we can move on to the definitions. There's starting on line 54, some of these things which you might have questions about, particularly what is an Article 6 probate court anyway? An Article 6 probate court is going to be a probate court for your larger jurisdictions, and they're going to have a direct appeal to the Court of Appeals. So we're really not going to be covering them with this. This is going to be for what we'd call non-Article 6 probate courts, those which do have an appeal to the state or superior courts. So clerk, we've defined clerk to try and have a broad definition to include both the traditional clerk in a court and also somebody who's acting as a clerk in a non-court body. In paragraph 3, decision is broadly defined so that we can bring in all of those quasi-judicial and judicial decisions that are subject to this process. Number 4, a final judgment. We just needed to make sure that whatever is being considered by the reviewing court has already gone through all the process that it needs to go through. There are certain conditions precedent that a case might need to go through in order to get to the review stage. So we wanted to make sure that it's a final judgment that is being reviewed. In paragraph 5, adjudicatory, we broadly define that to all the things that you'd suspect it to be: courts, commissions, county authorities, councils, and the important thing there is that they're exercising judicial or quasi-judicial authority. And those are the only decisions that are going to be reviewed under this, are decisions that are judicial in nature or they're quasi-judicial, meaning that a non-court entity is exercising authority that's judicial in nature. It's not going to touch executive functions or legislative functions of a body. It's only going to be affecting judicial and quasi-judicial decisions. In paragraph 6, lower judicatories, these are all the bodies that are subject to the supervision of superior and state courts. We're not upsetting anything there. It's all the same as current law. Paragraph 7, perfected. We're just giving their self-represented litigant kind of a leg up in defining what perfected means there, so that when they see it later on in how they need to serve process, they know what that means. So we're trying to give throughout, we're trying to make it simple so even your self-represented litigant has a chance to try and navigate this process. Person, it's pretty self-explanatory there. We're natural persons, corporations, all of those sorts of entities. And then in paragraph 9, a petition for review, this is the new process, the vehicle for the new process. A petition for review would replace all of the other processes that presiding Judge McFadden mentioned. And as such, if a Superior Court received some sort of document that had using the old nomenclature, say they didn't get the memo that we're switching to petition for review, the court would be required to construe that document as a petition for review. So it would follow the same process. Reporting, we're just following existing law for what court reporting means in paragraph 10. Respondent in paragraph 11, this is important because under the current process, we have something called the opposite party, and then we also have a respondent. People don't understand what those things are. And we get cases that have to go up to the Court of Appeals and so forth, because people are serving the wrong party, because they go, who's the opposite party here? They can't really figure it out. Who's the respondent? I don't know who that is either. And it turns out that respondent, in many cases, is going to be the official that made the decision. So guess what? They're going to have judges like Garrett Jackson back here at Atlanta Municipal Court, who's going to be sitting in court and have a sheriff walk in to serve him because he's the respondent in a certiorari review process. That makes him that would make him a party to a lawsuit. And that's not something that most judges appreciate. So we're getting that, we're eliminating that whole process, and we're redefining respondent to make sense with the modern conception of the term, that it's just the person who's adverse to the petitioner in the case below. So moving on to our last definition, the reviewing court, paragraph 12. This is going to be your superior state court, or just use that as a shorthand throughout, reviewing court. So when you see reviewing court, that's what it means, superior state court. Starting proposed code section 534 at line 95, this is where we're establishing the appellate jurisdiction of the superior and state courts. And you'll note that there's a list of certain things in B1 through 7. Now, all of these courts listed and certain subject matters listed, those have direct appeals to the Court of Appeals, or there's something that the superior state courts don't handle. Okay, so if it's going to be the Georgia statewide business court, the superior or state courts are not going to handle appeals from there. They're not going to handle appeals for the municipal court of Columbus. And it's a quirk of existing law that all of these listed courts here have a carve out along the way under Georgia law. So we've listed them here because no one else would be able to find them, especially someone without skills with legal research. This list has never been anywhere, so nobody knows what this list is. And so now the self-represented litigant even knows, okay, all right, these are these courts, no go. We're not going with those. And then also starting at line 110, it's clear that everything in here, this is state law. It's going to preempt your local ordinances and so forth. There's an issue with sometimes you have cities try and add on extra procedures to the appellate, this level of appellate process. We're trying to cut that out so that there's one process, no extra baggage lying around that you need to follow, just one process and it to follow. All right, so in proposed code section 535, line 113, this is our standard of review. So as provided in the summary, we're moving from 2 separate processes to one process. And we had to reconcile that somehow. And the way that we did it was that the default or standard of review is going to be a limited review along the lines of what an appellate court would do. And this A1 through 5 here is basically that. The fact finders are going to find the facts, and then the superior state court is going to review the case along those lines. Unless there's somewhere and sprinkled throughout the code, you will see that there are code sections that either require or prohibit a de novo review. And as we all know, de novo means basically a new trial, a do-over. So there are some code sections that require that. So we didn't change any of those as to not upset that. We kept that the same, the best we could, while still going into a unified system. So you're going to get a limited review unless somewhere in the code it says that you need to have a de novo review. So we left that alone. And then we have certain cases you might want to request a jury. So we've provided for that as well. 536, starting on 129. This is just, again, this language to telling you how you invoke the appellate jurisdiction of a superior state court. You file a petition for review, and that's how you do it. You don't need consent from anybody to do that, because under the current process, there's some confusion. You got to get consent for a writ of certiorari. Nobody knows how to do that. And so we're making it clear there's no consent required with it to get from anyone. Just file your petition for review, and you're going to invoke the appellate jurisdiction that you need. Starting on line 134, we have in A, we have, if we're not covering anything in here, we have, it permits that we can have court rules and orders kind of fill in the gaps, as is the case with most procedural laws. On B, starting on 138, this is how petitioner files a petition for review, and it has to be within 30 days after the final judgment of the lower adjudicatory, and that's consistent with the current process. We didn't change that timeline. We have a couple of nuances there. When does that time start? So we had to figure out exactly how to clarify that, because when you're dealing with both courts and non-courts, when exactly was the decision made? So it's easy when you have a court order to follow, but what if it's going to be like a, your county commissioners or some local board, they made the decision, they didn't put it in writing. Was it the day that they just announced it? Was it the day that they distributed the notice? Okay, so we put on here, it's a date that it's signed or that the notice was given. That starts the clock to accommodate that. Again, we had some confusion under the current process who the current parties are. So we made sure that it's clear in C, starting 143, all the parties are the same as it was in the lower adjudicatory. Because right now, as I said, we have, we have the respondent versus opposite party confusion. So we're clearing that up in C. And then again, we have belt and suspenders on D here to say that except for reasons other than having rendered the final judgment. So you can't, and that's going to be our judges again. You can't just name the party that made the decision as a party to the lawsuit just because they made the decision. Again, we're trying to get past that whole thing of judges being served as respondents in these situations. So we can fix that, and looking in line 149, 150, 151, you can fix that. If the petitioner does that by mistake, you can fix it. Then in starting line 152, we're giving the petitioner a format for the petition for review so that they just plug that in, and then voila, they have a petition for review, and trying to keep it as simple as possible while also including the necessary information. And if they fail to provide the information, there's a mechanism starting in F to try, it's amendable. You can fix it as directed by the court. Once the petitioner files their petition for review, they're going to need to file it, a copy of it on all the parties within 5 days, as on line 173 and 74. And then then also the petitioner is going to have to serve the lower adjudicatory with a copy of the filed petition. Now, this was something Judge Gary Jackson likes to say, is that he has a perfect record, well, almost perfect record on appeal, because he never gets notified of when he's reversed. There's no mechanism under the current process for if you have a writ of certiorari and the case gets reversed, the judge below is never going to be notified. They don't know, so they are deprived of meaningful instruction. So from the outset here, we're keeping the lower judicatory in the process by serving them with a copy of the petition for review to put them on notice that, oh, something's happening. There's a petition for review that's going to be, that was filed, and my decision is going to be reviewed. You'll see later on that they're also required to serve, that the clerk of the reviewing court is also going to serve a copy of the decision on the lower judicatory so that they're notified as well. So we got both sides covered. So starting in line 181, the next section, we have respondents filing responses. What do you need to include in your response? And B and C, replies by the petitioner. What do you need to include in your reply? Moving on to line 193, party can amend their petition for review, and it gives them the restrictions there. And finally, in line 199, a party must serve any pleadings on the other parties. So we keep all the parties aware of whatever is being filed. Starting on line 202, we have, this is really court management in 139, trying to give the court some tools to manage the proceedings. They can issue orders and writs, what they need to do to manage the court proceedings. They can grant continuances if they need to, but they want to keep a just and expeditious review going. And the court can also file, establish deadlines and schedules, all pretty normal stuff there. D, it's a little bit more complicated because really we're carrying over a code section, a current code section with regard to if you have one party that files an appeal, but what if the other parties don't, and so on and so forth. So this section here is really kind of a restatement of that current code section, and try and kind of smooth it out a little bit. And so that's basically current law there as well, lines 209 through 216. Also, line 217, monetary limitations. This is also a restatement of current law. That's something that's been worked out and by the legislature already, so we're not touching that. We carried that policy decision over. And then starting on 5310, we're going to have a section all about service of process. How do you do it? And who do you need to serve? How do you need to serve? And remember that definition of perfected in the definitions is going to be handy for your self-represented litigant there. Skipping on to a new code section 5311. This one is starting on line 248. This is going to be your deadline extensions. Now, the court can issue deadline extensions, but however, we wanted to limit the only one filing deadline extension not to exceed 30 days for the petition for review. We wanted to, keep the court's momentum going on these procedures to try and keep them efficient. And then as promised, we have in line 255, the clerk is going to be serving all of these things on the parties. If there's any extension granted under this code section and the corresponding motion, keep everybody in the loop. Starting on line 259, we have limited grounds for dismissal. So there are, we wanted to try and make sure that the reviewing court is considering decisions on the merits. That's the whole point of this thing. Okay, so we kind of limited the options for dismissal. We didn't want to be able to dismiss for any old reason. We want to try and incentivize the court and the parties to try and keep working towards a decision on the merits. So we listed some things there that we think are pretty common sense. Among those are failure of a petitioner to prosecute. If the petitioner just falls off the face of the earth and doesn't do what they need to do, then that's one reason that the reviewing court can dismiss it. Or if the petitioner fails to comply with the provisions of this chapter, which there are a lot of provisions that kind of give petitioners a second chance to try and get them to get their house in order if they don't do what they're supposed to do. And another one of those starting on line 261B is the reviewing court shall not immediately dismiss a petition for review because of a defect in it, because there's a defect in the bond or affidavit of indigence, or the failure of the lower judiciary to transmit any document. It says immediately there, and the intent of that is that they're not going to see the problem and say, okay, dismissed. They're going to try and give a chance for the parties to work it out, to try and to fix the problem. And so that's what that section is about. Again, and then additionally, there's in D 277, they don't immediately dismiss for failure to perfect service if they, but the party's obligated to show due diligence in attempting to provide timely service. Again, 5313, 218, line 218. It's basically venue. You gotta file your petition for review in the right venue, and if you don't, then it gets transferred to the right venue. So again, knocking down another procedural barrier. If you file it in the wrong place, you're going to get it moved over to the right place. 5314, starting on 288. We took a stab at modernizing existing code section 5641, which is the code section that's used to create the record for appellate courts. And so that basically tracks 5641 in somewhat modern fashion. So if you have any questions about that, let me know. But basically the gist of it is that there's a lot of mechanisms in there to try and create a record if there isn't a record. And it follows the same as the current process. All right, so moving on to the next code section, 5315. Starting on line 366, this is how you transmit the record. And in transmission of the record from the lower judicatory, they're going to include in there a notice if the petitioner is confined to jail or some otherwise incarcerated and so forth. And that's something that will help the reviewing court kind of take that into account with regard to scheduling. And we move on to 5316. This is a prerequisite that there is a prerequisite at times that you need to pay the cost below in order for you to get your appeal to the next court up. You don't have to pay all the costs to file a petition for review, but if you want your petition for review to be heard, you need to pay the cost below or file an affidavit of indigence saying you couldn't pay them. So that's one prerequisite. It's pretty consistent with current law in that regard. Starting on line 395, this is an exception in current law that we carried over for executors, administrators of an estate or other trustee. When you're defending an action, you have an exception there for the paying of costs. So we track the current system there, again, leaving that in place. And again, in E, unless the petitioner in a civil case files an affidavit of indigence with the reviewing court saying the petitioner is unable to pay because of indigence, the petitioner in a civil case must provide a certificate that they paid the cost below. And so either needs to, well, there are some requirements for the certificate there. So moving on line 412, we have some bond and security issues there. This is the code section that really governs, bond requirements and so forth. When you file a petition for review, it's going to act as a supersedeas bond. It's going to suspend but not vacate the final judgment of the lower judicatory, and you don't have to. You're not required to file a bond unless you're ordered by the court to do so. So bond is not a requirement. There'll be an automatic supersedeas bond invoked. And we have some other bond requirements throughout this code section, which basically tracks a lot of current law and who do you pay the bond to and so forth, which is again consistent with current law. We can move on to 5.3.18. These are what happens after review, giving the reviewing court some guidance there. What are some options that they can do? They can enter the judgment, they can order dismissal, or can remand it back with instructions, or some combination thereof for those things. So once the decision is made, as I alluded to earlier, the clerk of the reviewing court, it serves a copy of the decision on everyone and also on the lower judicatory. So there's meaningful instruction to the courts below, as they currently do not have. And finally, in 488, a petition for review can be appealed to the appellate courts as prescribed by law, which is pretty standard. All right, so line 490, proposed code section 5.3.19. This is really, it says what's going to happen if the petition for review is dismissed or withdrawn. And this tracks very closely 5.3 current law 5.3.7. And as I put in my summary, this attempts to kind of reconcile a case called Long v. Greenwood Homes. And that case, we have the interplay of 4 different code sections, basically, 2 of which we're going to repeal here because they're confusing. 5.3.7 is one of them. And that basically says that if you withdraw or dismiss the appeal, the rights of the parties are the same as if the appeal never happened. So it's dismissed. It's basically a reinstatement of what happened below. And that's the policy that we're trying to promote here. However, under Long v. Greenwood Homes, because of this quirk of these interacting code sections, if you went to magistrate court and you won on a civil case, then your opponent goes to superior court and files an appeal, then does a voluntary dismissal of that appeal. Guess what? That lower decision in the magistrate court disappears. It's eliminated. So you can completely make your lower court win. Your opponent can make it disappear just by going and fight. It's hard to believe, I know, but you can, if you have a civil case in magistrate court, you can win. Then your opponent goes to superior court and appeals it, and then voluntarily dismisses it, and then the entire thing is dismissed, including the lower court's ruling. Yes, it's a quirk of how all the code sections work.
That's current
together.
law.
Yes.
Okay.
So we're trying to correct that. We say that's not really how the system's supposed to work. So we're correcting that by getting rid of the 2 problematic code sections and repealing them and replacing them with this system. And this 5.3.19 is our attempt at not bringing that baggage with us. We don't want to bring that baggage with us. We're going to leave it in the old system, and this corrects that. So if your decision is dismissed or withdrawn, the lower court's ruling stands. Okay, and it doesn't matter what standard of review is. This is so we're correcting that matter. Moving on to line 503, we have if there's a frivolous actions or defenses in a petition for review, there can be damages. Reasonable and necessary attorney's fees and expenses may be assessed, capped at 20%, which is consistent with the current certiorari code section, 20%. So we're leaving it the same 20%. And to be fair, we do actions and defenses there. That code section 5.3.20 would only apply in civil cases where a petition for review results in a judgment for a sum of money. And moving on to 509, 5.3.21. This is recovery of costs. It tracks current law, we're bringing in different code sections in one place to track current law and how recovery of costs works. And those are all the substantive provisions. We've gone through all of them. The rest of it is conforming amendments throughout the code. We have one exception, which we tried to do a clarification for magistrate courts. And I've noted that in my summary that there's some confusion on into which court's registry a tenant is required to pay in disparate dispossessory cases. So we tried to clear that up. So that's a clarifying amendment. If you scroll to the end of the bill, we provided for an effective date of July 1st, 2023 to give us a good year to prep for this. And we have a mechanism in there that only the petitions for review filed on or after July 1st, 2023 would be subject to it. So there's a cutoff there to make it clear. And that's the fast and furious rundown
All right.
of the petition for review bill.
I know my colleagues probably have some questions because I have a few.
Sure.
The service of the petition for review
Yes.
is, well, you got 30 days to file your appeal.
Mhm.
And then you have 5 days to serve it. Is that correct? Am I reading that right?
We are in 5.3.10.
Yeah, you're at, looking at lines 170 to 174, right in there. More particularly 173 to 174, right? That line.
Right. They have 30 days to file it. And then once it's filed, they have 5 days
Okay.
to serve it on everyone.
I did very little civil work in my private practice, a lot of criminal and stuff. So, but as I recall, if you had your last day for the service that falls on a holiday or a weekend, don't you get an extension? Does that still operate by law under this? It does?
I would think so. It's entitled 1.
Okay.
Mhm.
Okay, all right, just, we want to make sure. And then jump over to page 18 line at the top of the page. The bond that you spoke about that might be required,
Yes, sir.
depending on what kind of case it is, I guess.
Mhm.
Does this set that out as to how it's invoked or how you do that?
Basically, it's an automatic supersedious bond. And then if the court requires a bond, like a cash bond or so forth,
Mhm.
then you would have to post the cash bond.
Okay, so really you're following the order of the court
Right.
to do the bond.
Right. It's
Okay.
not required, but if the court, it's not automatically required, but if the court tells you to do it, you have to do it.
Okay. And on to the next page, line or section C at line 488 and 489.
488, you said?
Yeah, it's the final decision
Okay.
by a reviewing court under this chapter may be appealed to the appropriate appellate court.
Right.
How is that determined?
Well, it's my understanding that under current law, each appellate court has their own respective
it's-
jurisdictions.
Okay, so it's based on that.
Yeah, we're not changing any of that.
Okay, all
Yeah,
right.
and under 535, this would be a discretionary appeal to the appellate courts.
Okay, all right. All right, that may be the end of my questions. Anybody have questions for the witness? All right. Representative Hawkins.
Thank you, Mr. Chairman. Appreciate the hard work that you've put into this. It's apparent. And Judge McFadden, I'm an alumnus of the Sutherland firm, so I appreciate your anecdote that they couldn't figure out how to appeal that issue. I may have to give them some razzing over that, but
Well, I should mention that it was an alumnus of that firm who was working on it with me back in the day, who was inspired by that experience.
excellent, excellent. I want to ask just a couple of practical questions, which of course, inform the application of the policy, because I heard you say a number of times, and I agree with it, that part of what you're trying to do is to simplify the process for
Right.
pro se litigants.
Right.
So with that, by way of example, in 5-3-7 for local rules, I'm wondering if we should have a requirement that local rules be posted online or accessible or available, like things like that, like just so we make it as easy as possible. If there are going to be some secondary rules that aren't in the OCGA, that those can be known.
Well, we should have, these should be rules as in uniform court rules we're talking about. So all those are posted on the Supreme Court's website.
Okay.
Yes.
So there wouldn't be any local rules that would be different from that?
Can be.
Well, we're trying to get away from that as much as possible.
Well, we're trying to get away from legislation that changes the substance of this act. The idea is that just like anything else that a Superior Court judge does, they would have their rulemaking authority would obtain, and whatever the procedures and protections are for establishing and publicizing court rules would apply to this as well.
Okay. Is there a one-shop place then where the rules would be available? Would it be on the Georgia Supreme Court website?
The Georgia Supreme Court website has all the statewide uniform court rules as promulgated by each class of court.
Mm-hmm.
There's no one clearinghouse for all the various local rules across the state, as they would be independent entities of cities and counties and so forth under our system.
Okay.
Well,
All right.
let me comment on that. As a chief judge, I wrote plenty of orders that became the rules of the court with, certain matters. I didn't, I can't recall exactly what all I had in them, but those were kind of local rules for filing and what you include in it, the forms that we would have people fill out, those kind of things would be mentioned in the order.
Right. And to the extent that those are not in conflict, they would be allowed.
Okay, so this will supersede any judge's order?
Well, it would have to be within the statutory system, within the same system. So the order couldn't deviate, like say, oh, well, the petition for review in the code says 30 days, but I'll give you, 60 days. You
Right.
can't. These would be the rules, and then any court rules, just like under the current system, court rules have to also comply with the statutes and so forth.
How does an individual who's not a non-lawyer, how do they find that out? That's
Right.
I guess just like the attorneys do, go look it
The
up.
idea, Mr. Chairman, is simply to incorporate the status quo in terms of the rulemaking authority of the trial courts and their responsibilities to make them public, and to the extent that there ought to be a better availability, more uniformity. That's just a problem we didn't try to fix. We just attempted to incorporate the status quo of that authority in these provisions.
Okay.
And with that, that same line of thought, Mr. Chairman, is what's influencing my questions is on the service issue. One thing that I sometimes have in the cases, oh my gosh, my pen's exploding. In the cases that I have is you'll have multiple parties, and I don't know if this would be an issue or not, but I want to ask the question in case it is. A number of parties will settle out. And so then to go to the appellate step, you would have to serve all of the parties, whether or not the appealable issue is relevant to all those parties. So one, is that an issue? Is there any way that we can simplify it? And then two, on the service itself, is there anything that we could do for pro se litigants to make that easier too? Because an overnight first class mail, overnight mail, all those things, which might be easy for some, are barriers to others. And so I want to just raise the question along the same line of this, making this as accessible and easy as possible, while also having standards that are clearly articulated and capable of being followed.
Well, I know we do try and promote electronic service. If you have, and we're all trying to make the process as easy as possible. So to the extent that if you have any ideas, we're open to them on how to improve the service of process procedures here. So, we're open to that, certainly.
Okay. Well, one thing I'll think more about that is a bias of mine. I hate legalese, and so I would strike hereby in line 158 and just keep it plain simple English of the petitioner named above petitions the state of the court, and get rid of the hereby. Very minor, but just the more complicated we make it, the harder it is for
Okay.
a lot of folks to understand it. I'll stop there. Thank you.
I share your your thoughts about legalese. Believe me, I'm a plain language guy, so I appreciate that.
If I could add, I believe that the language about all parties below or parties to the appeal is directly taken from the Appellate Practice Act. And I believe the service provisions are written with the idea that this is ongoing litigation. So the parties have figured out how to send things to each other.
Exactly. Yeah, and if they're already in the system, I'm assuming that the venue has e-filing. If so, then it really should be pretty easy. It would be the probably the other example, but some local entity like the tree ordinance.
Right.
Do you have e-filing at that venue?
Right.
Probably not,
Right,
right? And so that's what's raising. If we had e-filing everywhere, I think it's really a simple problem. It's in those instances where it doesn't exist, how do we make it as easy as possible?
Yes, excellent, very excellent, very much in line with what we're trying to do. So whatever suggestions you have, that would be great.
Okay, thank you.
All right. Let's see. Representative Evans.
Thank you, Mr. Chairman. I echo Representative Holcomb in saying thank you. This is a lot. My question, I have two questions. First on the section starting on line 95, but really concerning the list of courts in lines 103 to 109.
Right.
I like that. It's very clear, and I appreciate what you are trying to do there. But thinking about the future, we just created the business court. Who knows what another city or county or us may do in the future.
Right.
I wonder, and I don't know what the language would be, but I would just ask for consideration of some language or any court that, whatever these categories are, in case and it sounds like it, or any other court where there's a direct appeal to the
Right.
Court of Appeals or Supreme Court.
Yeah, that's the bottom line,
Yeah.
is that these courts have a direct appeal to the appellate court, so they're not subject to the jurisdiction of state or superior
Yeah.
courts.
I think if we add that language, that way we're not in a situation 10 years from now or 20 years from now where we've taken away or created conflict. And then on the next page on lines 127 and 128, where it's talking about a demand for a jury trial, just help my simple brain, since this is all about appeals. Tell me when this comes into play.
When there's de novo review and some matters are subject to de novo review, and consequently there'd be fact finding and potentially a jury trial.
As part of an appeal.
Yes.
Oh, right, because we're going from,
Right.
say, a board of commissioners to,
Mhm.
gotcha. Okay,
Yeah,
thank
and
you.
then the certain code sections require de novo review, so
Okay,
they're going to need to provide for mechanisms for that.
I was being too literal. Thank you.
Sure.
Thank you.
Anybody else? All right. Representative Allen.
With so much work y'all have done, I'm not sure this is something that the committee would want to spend any time on, but I'm really curious about lines 502 to 508 about attorney fees and appeals. Do you have any data or information on how many, if any, fines have been issued on frivolous appeals? One of the issues with pro se litigants is that they don't, sometimes it's intentional, sometimes it's just they don't know what they're doing, but a client paying somebody to 1, 2, 3, 4, 5 appeals is never sanctioned
Mhm.
in my long experience. And some of it comes from inability to maneuver, and some of it comes
Mhm, mhm, mhm.
by intentional delay to cost the other side.
Right.
That was not part of your work.
Right. Yeah, we haven't explored that, but it's worth noting that basically we're incorporating code section 91514. So it's existing law. We're just referring to that because there's already a good code section for that. So we didn't want to reinvent the wheel. And then kind of meshing that with the 20% cap that's already in the certiorari review code section. So we just basically said, here's current law, and we're capping it at 20%. So we didn't have an explored that issue in detail. And also we're carrying this concept over from current law as well.
And that
Mhm.
highlights that this is a policy question I'm raising. It's not really part of their work, but it's
Mhm.
something that's really troubling me right now. And I may think about it with some other of you around the table.
Very good.
Anybody else? All right, well, gentlemen, I wish that when I was a lawyer starting out and dealing with probate courts and appeals from
Mhm.
there, that I'd had a simpler process to go by.
Very good.
So this looks like some very good work, and I appreciate what y'all have done.
Thank you, Mr. Chairman. Thank you for your time.
All right. Judge Jackson, you want to come up this time?
Big chairs to fill. What Judge McFadden doesn't tell you is he wrote the book.
Yeah.
Yeah. And I believe I've mentioned that in Representative Gunter's presence.
Yes, several times.
He sure did. Oh. Mr. Chairman, members of the committee, thank you for your time and interest in this bill. I have been a judge in the Atlanta Municipal Court. I'm now in my 22nd year. And before that, a ProHack, I've been on the bench 34 years. And I began my career actually in this building as LC5 a long time ago. And I will tell you, with respect to my distinguished double dog over here, I have a degree from Georgia, and I do not understand this system. It is a holdover from horse and buggy days when the judges carried the court on the saddlebags. And this system is so bizarre that I would say 98 to 99% of all cases that go up on appeal, at least from municipal courts, get dismissed for procedural reasons. If you don't dot the I in the right place, you don't cross the T, and if you don't dot the J, it gets dismissed. And I'm sitting on the bench in my 4th decade, and I never get feedback. I don't know, is what I'm doing correct? Or have I made a mistake and I need to do things properly? You never get feedback because all the cases get dismissed. The self-litigants don't have a chance. And most of the lawyers, when they hear the expression certiorari, they're thinking, well, I'm going to the state Supreme Court from the Court of Appeals or the United States Supreme Court. But here it is down here. And this bill will take a lot of work, not only off the desk of Superior Court judges, but off the sheriff's desk as well. When a cert is filed, it goes into a Superior Court judge, and I'm told by so many of them, they turn to their clerks and say, what is this? And they have to sanction it. Then it goes to the sheriff, and in the middle of a court session, in walks a uniformed armed sheriff serving me with a paper. And I'm named as a defendant. That's not a pleasant thing to do, and it's a waste of judicial and law enforcement resources. This bill eliminates that entire procedure because the Superior Court judge or the state court judge is not going to sanction anything. The sheriff doesn't serve anyone. And when I look on my credit rating, I find out, oh, you're being sued in this lawsuit. I went to refinance my house. I needed a letter from the city of Atlanta attorney. Judge Jackson is not a true defendant in this case. He's merely a figurehead, and try to explain that to a mortgage company. And this goes on and on and on a regular basis. So the litigants get tossed out. There's never a decision on the merits. The judges below have no idea whether they're right or wrong. And if we're wrong, we need to be told that and get things right and get the answer, which we never, ever get. It just doesn't. Finally, a case was done properly. I was reversed, and I was glad to know that a particular procedure I had with a defendant who wasn't observing the terms of a sentence required an extra step of procedure. And even though I was reversed, I was actually grateful. So now I can do this correctly and make sure that everything is fair, because traffic cases, they're criminal and your job can depend on it. And the ability to get to a doctor can depend. A lot of things are important. And we in municipal court, of course, see more litigants and defendants than any other class of court. My court today was a small day. I had 148 cases, usually around 200 before the pandemic, about 300. We have a tremendous volume, and there'll be a certain number of litigants who are dissatisfied with the result and want to appeal, and they're representing themselves. They're self-represented pro se litigants. And when you tell them certiorari, they can't even pronounce it, spell it, and have no idea what to do. And this bill eliminates all of that. And we've been working on it a long time. This notebook I have is volume 3 of a 3-volume set. And Mr. Enns and Judge McFadden have done a tremendous job. And there's so many anomalies in this law. A landlord sues a tenant for rent in magistrate court, and the landlord wins. The tenant files an appeal. 2 days later, dismisses the appeal. Now, in every appeal in Georgia, when an appeal is dismissed, the clerk sends it back to the court from which it came. Not in a certiorari. The whole case disappears. The landlord has nothing and has to start all over again. And that's what the statute requires. And this is one thing that will be overturned. But most importantly, when I was reversed in that one case, the Superior Court of Fulton County Clerk never sent me the judgment, because there's no remediator in statute that tells the clerk to do that. I had to stay abreast of it. Let's say a defendant has a fine to pay, files an appeal, and loses. Well, that fine needs to be paid. If the Superior Court clerk doesn't tell me on remediator, judge, this case has been affirmed, you need to collect the money, that fine never gets collected. That sentence is never served. That license suspension of the community service we ordered never goes into effect, because believe it or not, there's no remediator in this current law. There's so many gaps. And as Judge McFadden said, if we can just get into the 20th century, we'll be very happy. But this bill does a lot to correct a lot of mistakes, give the litigants, the self-litigants, and the lawyers a chance. And we have publicized this bill extensively. It's been up for public comment in the bar. It's been through the AOC Legislative Committee, whose chair at that time is now our Chief Justice. There's been a lot of hands and eyes on this bill, and we welcome any corrections. You can get a lot done if you don't care who gets the credit. We need to get out of the horse and buggy days and get into something modern that's simple and gives a decision on the merits, not just, oh, you missed this, and oh, by the way, there's no chance to amend your mistake and correct it. You can't even do that in most instances. This bill repeatedly says, if you made a mistake, the state or superior court, appellate court is going to say, you need to do this. And then, and only then, if you don't do this, then we're going to dismiss the case. Everybody gets a chance to get it right. And as a judge sitting on the busiest court in the state, I and my colleagues, and I think I speak for all the other judges, I'm a past president of Municipal Court Judges Council, we want to get it right. We want to do the right thing. And if we're wrong, please tell us. And right now with this system, we're just completely left in the dark. And we're never even told when we win, and we're never told when we're reversed. So I welcome any questions, and I thank you for listening to us. It's a complicated bill, but The reason it's so complicated is because the system is so complicated.
Sure. Any questions? Not seeing any.
Well,
Thank
thank
you,
you
Judge.
very, very much for taking the time for this long piece of legislation.
All right, we'll get the last in-person, Cheryl Karunas. You're good? Okay. All right, then we'll go to Judge Margaret Washburn.
Hello, everyone. Can you hear me? Is it working? I don't know if you can hear me or not.
Can you hear us?
I can hear you, yes.
Okay, we can't hear you. Hang on just a second.
Yes.
She muted or?
Mine's
She's
not
on
on
mute.
mute.
She's not? Can you? All right, go ahead and speak so we know we got you.
All right, is that coming through?
Still no sound.
Oh, goodness. Well,
Mr. Chairman, she did text me and say that she was having some issues with the audio, that she could hear us previously, but had hoped that her mic would work when she was called on.
Okay. We have any way to fix it? Okay. Judge Washburn, I may have to come back to you. We'll move to the other, Judge Barker, Michael Barker.
all right.
Can everyone hear me?
We're waiting to hear, see if we can get it going.
Can everybody hear me now?
I heard it. I think I heard him. Can you turn the sound up?
How about now? Is that loud enough? Okay.
Well,
I see
we got
some
you on the
nodding.
computer. We don't have you on the main system. Let's see.
Well, I really don't have a lot to say. I learned a long time ago not to follow Judge Jackson. So I'm here to answer any questions from the magistrate court perspective. If anyone has any questions about how things might impact our court and our system.
All right, Judge Barker, hang on.
In the upper left corner, it says original sound off. I don't know if that's.
Thank God I have 17-year-olds.
You see what he's talking about on the screen, original sound off. I don't know. Do we have our IT folks working on it? All right, Judge Barker. Now
Yes,
we're
can
getting
you hear me
feedback.
now?
I can.
Just yours.
Yeah.
All right. Judge Barker, can you sound off?
Yes. Can you hear me now?
I'm just hearing you over the computer. It's not helping.
Controlled by my computer. It's being controlled by the overall system.
Okay. Can you get them? Can you text them? We'll stand at ease for just a minute.
Can anyone hear me?
Compliment you on Mr. Willer's photograph. That's very good.
You need to compliment Chuck Estration. He had that done, and I think it's very appropriate.
It does feel like he's watching over.
I'm sorry.
It does feel like he's watching over.
Yeah.
Can anyone hear me?
Oh,
I can hear you on the computer, but not through the system.
Oh, goodness. I don't know what to do to fix that.
I don't know that she heard that you had him check
Yeah, we're going to our IT folks to see if we can get it running through the system.
Well, at least if somebody can hear me through the computer, that's better than a few minutes ago.
Yeah, now she's off.
And it's off again.
It's all gonna be delayed.
Yeah.
Well, that's a plus.
Judge Washburn, can you sound off and maybe we can hear you?
I can hear you.
Yeah, we got it. Okay,
My whole building can now hear you.
we can hear it good now. All right.
Oh.
Judge Washburn, we'll start with you then. Go ahead.
All right, and thank you, sir, and thank you so much for taking the time to put this together, and certainly to those that prepared this. And Judge McFadden may recall that I reached out to him a couple of years ago, and also to Representative Upstration, as well as to Darren, about this situation. I agree with most, well, usually with everything that Gary Jackson says. I was named as a defendant in the Superior Court of Gwinnett County, Don Robb Investments versus the City of Sugar Hill, and also Margaret Gettle Washburn as a respondent. And Judge Jackson is absolutely correct. Refinancing a house or any other matter that comes up where someone is asking about your background, whether or not you've ever been named as a party to a, this shows up. This still shows up on Gwinnett courts that I've been named as a defendant. And I did not get served by a deputy sheriff. I was notified by the petitioner that this was being filed, and I agreed to sign an acknowledgement of service. And of course, that's what got the ball rolling. But nonetheless, being named in my official capacity as Chief Judge for City of Sugar Hill. So I believe that what caused this, and I agree with Gary, that it was the horse and buggy days, but before we had passed 36, before you passed 36-32-1.1, which changed the requirements for being a municipal court judge. You have to be an attorney and a member in good standing with the state bar. But before that, we were not required to be attorneys, and there weren't always clerks and judges, perhaps, that were as efficient as most of us are fortunate to be now. But in 2011, that was changed, and lawyers, it was only lawyers that could be appointed to the municipal court. I think that goes a long way toward what we have now. I think this new legislation will be much better. I am very appreciative of lines 90 and 145, where the judges cannot be named as parties. What happened was that with that is it was filed, it went to the Superior Court. Judge Warren Davis presided, and it was named, I was named, and really all I should have had to do was have the court clerk certify the record to the court. I believe that your streamlined bill will also take care of that, where the clerk is the one responsible for having the record transmitted to the Superior Court for review. But in any event, I ended up having to do a 18-20 page brief. And it seems so odd to me, and this is what I asked Judge McFadden about, is that the City of Sugar Hill was actually the defendant, but the judge got named as a respondent again because of this odd system that we've got. And so instead of just certifying the record, I actually had to respond on behalf of myself as a named party so that I would not be in default. And fortunately, the judge in the Superior Court, unlike Judge Jackson, I was actually affirmed But there was an order then that came out of the Superior Court of Gwinnett County, which set forth why I was named as a respondent, that I made my pleading, that the city of Sugar Hill filed their pleadings, and that the judge basically found in favor of the respondent. But to me, that just looked odd because I'm not actually a party, and it looks like a conflict to me for a judge to have to file their own response to defend an order that they wrote on behalf of the city. It looks like a conflict of interest to me, but in any event, that's where we are right now. So it was appealed to the Court of Appeals after that, and then the Court of Appeals issued an order that upon consideration of the application for discretionary appeal for the denial of the application for the writ of certiorari, that we were affirmed. But again, I agree with what Judge Jackson and Judge McFadden both have said. This is a long process, long overdue to be streamlined. And I thought it was interesting where in my particular situation, the court hereby sustained the decision of the respondent judge below. The judges ought not be named as respondents. And I do hope that you will give this every bit of your consideration in passing this legislation and take some of the conflict of interest out, streamline the process for the defendants, both the pro se and represented defendants. And I think that'll just, and I think looking at this particular part of the code section where you've got 5-3-15 on page 15 with regard to the clerk, I do think that that helps streamline it as well. So I appreciate the opportunity to speak today. Thank you.
Thank you, Judge Washburn. Anybody have any questions? Representative.
Thank you, Mr. Chairman. Hi, Judge Washburn. Just one quick question, and I'm certainly sympathetic to what you said. I'm Scott Holcomb, Representative Scott Holcomb. If you are named, since by force of law, if this were enacted, it would be void. I'm assuming that then we would just treat it as void ab initio. And if you were asked if you had any litigation, you could just honestly answer no. Is that fair or no?
I don't think so, Representative. You said Representative Holcomb, is that correct?
Yes.
Okay, and honestly, I looked at that, and while everybody was online, I went online to www.gwinnettcourts.com, and of course, I come up with all the cases that I try because I'm in private practice. But then it came up pretty much at the bottom of the first page where I was named as a defendant in this case, and it comes up as being named as a defendant. I do think that, I'm not sure if that answers your question, but all of these cases do show up. If this is passed as it is, then the judge is no longer named as a respondent. Is that correct? As it's written.
Right. And what I'm asking is if a petitioner were to still name you as a judge, would I get the idea, which is to avoid that from happening, but if it were to happen.
It looked to me from the proposed legislation that there is a way that that would be corrected. Darren, are you still around? Is Mr. Anderson there? But it looked to me that there was a way by which that would be corrected on one of these, where it could be amended, yes.
If you'll speak into the
I
microphone.
can't find the exact line right now.
Well, I guess it is in lines 145 down, as it does give the court the ability. So the court could just change it and mark off the name. So that would fix it.
Yeah, you would be able to, the court would be able to correct that right off the bat.
Okay. And so it would be.
That's what it looked like, page 7, right, section D. It looked like it would be corrected.
So for our judges, they would be able to answer no if they were ever named as a defendant, because that would be incorrect, right?
Right. Yeah,
Okay. That's what I'm driving at.
They're not, according to this legislation, they're not a party, and they can't be named as a party.
Exactly.
So that would be an error. Yes.
So that they get, this gives them the protection that she's looking for.
Right. That's the intent. Yes.
It looks as though the reviewing court would have the opportunity to correct maybe the caption of the case, where it's styled as, in this one was Don Robb Investments versus Margaret Washburn versus City of Sugar Hill. The reviewing court, which would be the Superior Court, of the city, of the county where the city is located, that the reviewing court would then be able to correct that error.
No, okay. All right, any other questions? All right, Judge Washburn, I think that was it. Thank you.
I appreciate the time on this. I truly do.
Okay. All right, we'll go to Judge Barker now.
Can you all hear me now?
Yes, we can.
Okay, well, I've learned one thing on this committee, it's very difficult to follow Judge Jackson. So my only point is this procedure really doesn't affect the vast majority of things that come out of magistrate court. A normal de novo appeal is being preserved both in substance and in procedure. This just streamlines the method by which it can be sought in another court. What this act really does are the very small percentage of cases that would assist in the speedy and meritorious review of default cases that might actually require the old certiorari in order to review, because under current statutory law, there is no direct appeal from a default judgment. You have to have it reviewed by certiorari. But now the petition for review and its simplified procedure would allow more individuals to seek that sort of legal review of a default situation, and it would give them more access to justice. Aside from that, I really don't have anything else to share unless you have questions how this may impact us from the magistrate court perspective.
All right, committee have any questions? I don't see any, Judge Barker. Thank you.
Thank you for your time. I appreciate it.
Mm-hmm. And go to David Metzger. See there? He's on. Mr. Metzger, can you hear us?
I can hear you. Can you hear me?
Yeah, we got you now. Okay. Go ahead, please.
Well, good afternoon to everyone. My name is David Metzger. I am a lawyer in Decatur, Georgia at the law firm Williams Toothink. I am known as a dirt lawyer, meaning that I practice real estate law. And as part of that practice, I do a lot of land use work, zoning, permitting, obtaining licenses for various local governments. And several times in that process where I've been involved over the years, we have been denied an application. And the only remedy to appeal that denial is through certiorari. And so this is an aspect of the current state of affairs that maybe hasn't been touched on quite so much with the judges. The current certiorari statute is used a lot to appeal decisions that are not coming out of the courts, but coming out of decisions by various officials and bodies within counties and municipalities in the state of Georgia. And so if your business license application is denied in the code of ordinances for that city or county, there's often a provision that says, well, you can appeal this, but it has to be through certiorari. The certiorari process is very, very cumbersome. I'm happy to entertain questions about some of the details of what is currently out there today, but it is archaic. It is very, very difficult to maneuver and handle, even as a practicing attorney. It is impossible for someone who is pro se. And this applies to a lot of applications and things that people are trying to get where they shouldn't have to have a lawyer. So trying to get a business license, trying to get an alcohol license for your restaurant, trying to get a sign permit. If you go down to at least back in the pre-COVID days, if you went down to the DeKalb County Planning Department and you looked around at the people who were applying for these sort of things, you see a lot of immigrants, you see a lot of non-English speakers. And for them to try to navigate the process of obtaining certiorari it has the functional effect of keeping them out of the courts and making a decision which can have a great impact on their business, on their livelihood, on how they can use their real estate. It can have a tremendous impact on that, and they really have no recourse. And so this update of the law and this simplification of the procedure is very, very much needed. I'm very much in support of it and look forward to working with everyone involved to try to make it the best, most efficient law possible. But right now, the situation is just very, very complicated. And frankly, it puts a great burden on the municipalities who have to try to decipher people's attempts at appeals, people who are named in these certiorari lawsuits, and in the superior courts who have to handle the appeals when they get there and try to decipher the procedures and rules and see whether or not the procedure has been applied for. So it is sorely needed. I compliment everyone who's been involved in this process. I know it's been a number of years in the making. And with that, I will entertain any questions anyone has about the current procedure with certiorari.
Questions by the committee? There we go. Representative Holcomb.
Thank you, Mr. Chairman. Hi, David. This is Representative Scott Holcomb. Please give my best to Kyle, Eric, and Lawton, your colleagues. But my question is, and I don't work in this area, is in the administrative agencies, like you mentioned. One of the things that we were discussing was trying to make this as accessible as possible, particularly for those who are pro se. And one of the questions was in terms of service, do most of those entities have e-filing, or will it have to be some type of paper service? And is there any way that we could simplify that part beyond what's already in the proposed bill?
Well, I think that's a very important component of simplifying the current structure. The current state of affairs, after you file the petition for writ of certiorari, you have to serve all of the respondents and the opposing party within 5 days. Now, the biggest distinction that I see with the current state of affairs in this proposed legislation is currently that service, at least on the respondents, has to be personal service by the sheriff or sheriff's deputy or the petitioner or their attorney. And so that means you've got 5 days to physically serve papers on these parties, some of which are frankly not used to being served if you're trying to track down a development director or someone like that. That's very difficult to do. When I focus on a writ of certiorari, the first thing I look at is what are we going to have to do in terms of service, because we only get 5 days. So my understanding with the new bill is you still have 5 days, but there is not a requirement for physical service. And while I know there is an allowance, I think, for electronic filing, I believe, and I could be wrong, that you can also serve by mail. And so, to me, right off the bat, that's going to be dramatically easier, a much lower burden if you simply have to or are able to serve by mail. Now, there may be a question of who you address it to for, a particular board or body or something of that nature. But, I think that idea of being able to serve through mail, something that roughly parallels what's out there in the Civil Practice Act, I think helps quite a bit.
All right. Thank you.
Any other questions? All right, seeing none. Thank you, sir. And we'll move on to Brandon Bullard. He's out. Okay. And now down to Billy Scott, or he's out too. Well, I think that's all we got then. All right. This was hearing only. There was some discussion about taking out the word hereby on page 7, line 158. And just in prepping for next week.
some language after 109.
Pull your mic around to you.
Also, Mr. Chairman, sorry, thank you. Adding, Representative Evans had a suggestion to add some sort of catch-all language after line 109, any other court where a direct appeal to a Statesboro court is not provided.
Right. Is there any other possible amendments to it?
I would check with some of my other witnesses who were here and see if there were some other proposals or suggestions made, and I try to follow up with the individual members on that.
All right. Tyler, you, okay, all right. All right. Anything else from the committee? All right, ladies and gentlemen, we're adjourned.
Thank you, Mr. Chairman.